So yes, today we will take up two more maxims of equity. The first one will be equality is equity, also known as equality est equitas est equalitas. Equalitas. Sorry, I don't know how to properly pronounce that. So it essentially means equity likes equality, also known as equity delights equality. Okay. But as I told you guys earlier, here we are not to assume that equity wants to establish absolute equality. No, it doesn't want to do that. Okay. It essentially what it wants to achieve is put people at where they should be. I mean, if you apply the law, someone might be at completely disadvantage compared to others. Okay, so strict adherence to law would put someone at complete disadvantage compared to others. But equity does not like such complete inequality, complete disadvantage of one over that of compared to the other. So it tries to achieve some kind of equality, but as I told you, it's a proportionate equality. It's not absolute equality. It's not that if there is 10 rupees is to be divided in between two persons, as five rupees each. Not that. I mean, it will try to distribute that proportionate to what you deserve. Okay, so that's what it does. But maybe application of the law would have ensured that one gets 10, other one gets nothing. So that's the kind of equality that it tries to achieve, basically based on what you deserve. So there is no general meaning. I mean, the general meaning of this equity has nothing to tell us. Okay, it is only in its specific application that it has any meaning. Okay, so it essentially means that a court of equity will, as far as possible, put the parties to a transaction on an equality. Okay, on an equality, although strict rules of law may give one party an advantage over the other. So if they were to apply only the law, then it would put someone at complete disadvantage compared to the other. So equity brings some kind of approximate equality between them. Okay, so that's proportionate, as I said, not absolute. Okay, and how is that proportionate? I think examples will make that clear. Okay, so the court of equity will, as far as possible, put the parties to a transaction on an equality. Okay, although the strict rules of law may give one party advantage over that of other. Okay, so this equality, again, as I said, is only proportionate equality and not absolute equality. Remember the example that I gave you. Okay, so I think you will understand this maxim better only when it is applied in specific cases. Okay, so what are those? The first example of application is the doctrine of contribution. Okay, so what happens in that case? So it's essentially a case of joint debtors of. So if there is a creditor and if there are like multiple debtors who are joint debtors, now what happens in case of joint debtors? That, for example, 3,000 rupees, 3,000 is owed by A, B, C, who are joint debtors, towards D, who's the creditor. Then the creditor can get that 3,000 realized from any of these three. Okay, so for example, A is compelled to pay 3,000 to D, who is the creditor. So now in law, A had nothing, no remedy as against the other two joint debtors, that is B and C, because D only realized the debt as against A. So there is no help from law for A, against whom the entire amount has been realized. Okay, so strict application of the law, as we said, would create this kind of situation. So equity avoids such unequal situation. So even though A will have no remedy under the law, A will have remedy under the equity. So to that extent, it can get the other share realized from the other two. Okay, so if the other two are capable of paying 1,000 each, it will be realized from them. Okay, if one is not capable of paying the entire 1,000 rupees, so for example, from the assets of, for example, C, you can realize only 500 rupees, so that will be taken, and the remainder, what is the remainder? 2,500. That will now be distributed between A and C. So A has already paid 1,000 rupees here, so he will be entitled to 500 from C, and B, from B's property, 1,250. So this is the kind of equality that we are talking about. So I hope you guys understood. Is it clear? The doctrine of contribution. You have probably studied this already in other subjects because it's already there in contract, Indian Contract Act. I hope this is clear. Okay. So this idea of joint debtors, doctrine of contribution, although is an equitable principle, has been incorporated in Indian statutory law. So in Indian Contract Act section 43 talks about this idea, okay, of contributions. It says when two or more persons make a joint promise, the promisee may, in the absence of express agreement to the contrary, compel any one or more of such promisers to perform the whole of the promise. Each promiser may compel contribution, okay? Each of two or more promisers may compel every other joint promiser to contribute equally with himself to the performance of the promise, unless contrary intention appears from the contract. Now, if the contract itself says that they'll be liable only to a certain extent, then of course it doesn't go against that. But the general idea is that equity does not like this idea of joint debt. More importantly, the equity it is said that equity does not like joint tenancy. Now, anyway, this is the case of debt, money. The same applies in case of tenancy with respect to estate. So hence, what I just said, that equity dislikes joint tenancy. So what does that mean? It's the same. So for example, if there were joint tenants, okay, so if the tenancy is joint, if one of the joint tenants die, the rule of survivorship would apply. Okay, what is that rule of survivorship? If you remember, we had discussed this in jurisprudence already. What happens is that the one who survives, the other. So for example, A, B, C were the three joint tenants. Okay, A dies. Okay, then B and C will, by survivorship, get what A was entitled to. So basically, A's tenancy will go to B, C. Now, as I said, equity abhors, equity dislikes joint tenancy. Okay, so what happens then in such case? So what happens is that equity considers in such situation that although the estate is now with that of B and C, but they are held to be holding that portion of the estate in trust for the inheritors of A. Okay, so that's essentially the idea of joint tenancy. Okay, so it says that equity leans against joint tenancy under common law on death of joint tenant. The whole estate belongs to the survivor. That's the rule of survivorship, and nothing was available to the representative of the deceased. Okay, but under this particular maxim, when applied by the court of equity, the doctrine of survivorship is negated to the extent that these other surviving tenants are held to hold the property in trust for the representatives. Okay, if someone is to inherit the property, so heirs they will hold the property in trust for them. So that's the application of this maxim. Now, why is it the application of that maxim? Because you see that application of the hard law would ensure that would ensue that one of the parties is like at complete disadvantage compared to the others. So in such situation, equity brings about some kind of approximate equality. Okay, so that's what happens. Now, why am I saying like not approximate, it's proportionate equality? Why is it proportionate equality? in the sense that, for example, heirs or representatives, inheritors here that I was talking about, they will have like that beneficial interest only to the extent that A had, A's proportion in the property. So that's why it is proportionate and not absolute equality. It's not that that entire estate will be divided, into three, and then the portion one third of that will be held by the other two in trust for the heirs of A. Not that. Only to the extent that A was, entitled to the estate. So that's the second example of this application of this maximum of equality is equity, also known as aequitas est aequalitas. The third example is rateable distribution of assets. Okay, this is also again something that you guys have already studied. Now, what happens is that in application of this in rateable distribution, what happens is that no priority is given to any creditors. Okay, and instead, preference is given to, like essentially what happens is that no one specifically is given priority among the creditors. Okay, so what happens quite often is that, suppose I am the debitor and there are creditors, 2 or 3 creditors. You need to have more than one, creditor, so 2 or more creditors. So under the application of the common law, okay, what happens is that among them, some of them, maybe because of the rule of priority or maybe whatever other rule, they are not given their, they do not get what they, they were supposed to get from the, debitors, okay, because of application of certain laws. So, for example, priority of the debt, maybe, okay. So, by application of this maxim, okay, in rateable distribution of, assets, that is negated. Okay, so everyone is given to, proportionate to what they are entitled to from that of the debitor. The same, doctrine has been incorporated in Indian Succession Act, Section 330, which says rateable abatement of specific legacies. Okay, so if the assets are not sufficient to answer the debts, the specific legacies, an abatement shall be made from the later rateably in proportion to their respective amount. So an example again, okay, so to make it more clear, so suppose A is the debtor, B, C, A, D are the creditors. Okay, now they are all they all are owed money by A here. Okay, but if B's debt were to be realized, okay, from as against A, then C and D will be left with nothing. Okay, if B's complete debt is realized as against A, C and D will be left with nothing. But if B is given only B's only certain portion of the debt is realized, then C and D also get something. So the distribution happens according to the proportion of the debt that they are entitled to. So that's the doctrine of rateable, abatement of rateable distribution of assets. Okay, the same principle can also be seen in Section 73 CPC, where it says, whereas assets are held by court and more persons than one have, okay, before the receipt of such assets made application to the court. So here you have to make application to the court. It doesn't just happen on its own. For the execution of a decree for the payment of money past, okay, against the same judgment debtor, okay, have not obtained satisfaction thereof, the assets after deducting the costs of realization shall be rateably distributed among all such persons. So essentially what happens, the outcome is the same, that all creditors, if the law were to be applied directly, some of them will be, for example, at disadvantage, but here, because of equity's intervention, the debt is rateably distributed. The asset is basically rateably distributed among all the creditors. So that's another application of the same maxim. The last example is uh, marshalling. Again, something that you have studied under the Transfer of Property Act. Okay, so same case arises here as well. Okay, so you have one debtor and two creditor. Okay, two or more creditor. Okay, and what happens is that one of the creditor has right as against one of the funds owned by the debtor. If there were two, the other creditor has access to two of the funds of the debtor. Okay, now what happens? Okay, so as you know, one of the creditor has right as against only one, the other one has as against two. Now what happens is that the creditor who has right as against two funds, okay, so for example fund A and fund B, okay, if he realizes his debt from fund A, on which the fund as against which even the other debitor also the other creditor also has right, then that other creditor is left with nothing. Okay, so in such case, equity basically helps in distributing this credit, so that both of them, okay, get their debt realized. Okay, so that's essentially the case. Of course, this will keep in mind the idea of priority between them. Okay, so to the extent that it doesn't affect the rights of others, it is the debt is marshaled in such a way that both the creditors are able to realize their debt, the right as against the asset of the debitor. Okay, so the same rule has been can be seen in section 56 and section 81 of the Transfer of Property Act. Okay, so section 81 says that if the owner of two or more properties, okay, if the owner of two or more properties, so here the example that I gave you for the simplicity's sake, we just took two property. Okay, so if owner of two or more properties mortgages them to one person, so first mortgage is to one person, okay, and then mortgages one or more of the properties to another. Okay, so and then you could either mortgage one or more than one to another person. In such a case, the subsequent mortgagee, because he has access to two properties, okay, is entitled to have prior mortgage debt satisfied out of property or properties which are not mortgaged to him. This will not affect the right of the prior mortgagee who has acquired an interest in any of the properties for consideration. Okay, in the absence, of course, it is subject to absence of the contract to the contrary. So essentially what happens is quite simple, that because one person has access to only one property, the other one has access to two property. Okay, if the one who has access to two properties gets it realized from, for example, from the property in which the other person also has some right, then that person will have, because of priority, no remedy at all. Hence, in such case, the person who has access to two property will have to realize, basically the application of this maxim, doctrine of marshalling, will ensue that that debt is realized from the property, so from that property, so that the other person's rights are not affected. So that's essentially the idea of marshalling. But under under Transfer of Property Act, section 81, the provision which we have just discussed is again subject to contract to the contrary. So this is nothing, again, the same maxim as is applicable here. So I hope this was clear so far. Is it clear so far? There's nothing new. You guys have already studied this in Transfer of Property Act, CPC, etc., etc. Okay. So yes, we will take up the next maxim then. Okay, the next maxim is equity looks to the intent rather than form. Okay, so what does this maxim mean? Okay, I'll deal with the attendance thing towards the end of the class. So yes, the next maxim is equity looks to the intent rather than form. Okay, so as you know, historically, uh, equity emerged because common law was too formal, and because of the formal requirements, justice was not done. Okay, so equity sought to do justice by looking beyond merely the formal requirements. And it is very much possible that sometimes, although formal requirements have been fulfilled, mm, that in itself is not sufficient, because there are certain other factors that the law is not able to take into consideration. So in such case, whatever other factors are there will be taken into consideration by the court of equity to the extent it is allowable. Okay, so that factor here in this maxim is the intent. Okay, so you probably already have the inkling as to what we are talking about. Okay, so for example, two parties enter into a contract. So when they write it down, okay, the contractual stipulations, that's the form. Okay, but maybe from the from how it has been written, you are not able to directly arrive at the intent. Okay, so in such case, maybe some degree of violence is done to that formal written documents so as to arrive at the real intent for which the contract was entered into. So essentially what is behind here is the same idea that justice is to be done according to the conscience. Okay, so equity regards or focuses on the spirit and not the letter of the law. Okay, so the spirit of the law is more important than the letter of the law. So this, if you remember, your interpretation of statutes sounds a lot like purposive construction, isn't it? That you look at the purpose rather than merely letter of the law. But it's not the same though, because the reason is that we have specific cases in which the said maxim is applied. It's not of general application. Okay, so yes, essentially the idea is the same, that equity regards spirit and not the letter of the law. So equity will not allow justice to be withheld because of technicalities. So if there are certain technical flaws, that will not be used to deny justice to either of the parties. Okay, so formal requirements should not frustrate justice. Okay, so if formal requirements frustrate justice, then that will be disregarded. Okay, so examples of the same, for example, is a contract under a seal. Okay, so when a contract is entered into under a seal, it is assumed that mere presence of the seal means that it's a valid contract. But what if the consideration has not been paid? So even the formal requirement has been fulfilled, court of equity under its equity jurisdiction will also find out whether the consideration has been paid. If not, then mere formal requirements will not be sufficient. But this remedy will not be available to you under the court of law, that is called common law. So I hope this is clear so far, what this maxim talks about. The same applies to, say, for example, transfer of property through sale. Okay, so now sale of a land might have certain requirements, that it has to be written down, it has to be signed by a certain number of witnesses, and that it has to be registered, whatever, etc. Those requirements might be there. Okay, so those are the formal requirements. Now, for example, for some reason, for example, for the fraud of because of fraud on the part of one of the parties who promised to fulfill these requirements but doesn't. Okay, the conveyance is not proper. So in such case, under the court of law, due to statute of fraud, no remedy will be available to you. But under the court of equity, there's a doctrine that court of equity will not allow statute of fraud to be used to commit frauds. Okay, so that's essentially what this maxim is all about. Okay, so Lord Thurlow had said the rule is that where penalty is inserted, okay, only to secure enjoyment of an object, the enjoyment of that object is considered the principal intent of the deed, and the penalty only occasional. Now, in the absence of examples, I think this will be yeah, complicated for you. Okay, so let's take some example for us to understand the meaning of this maxim. So there is something called rules against penalties and forfeitures. So what is that? So let me first give you an example with regard to contract, and then we will look at the provision. So for example, A and B enter into a contract that something has to be done on certain day at certain place, and some consideration is paid, is to be paid. Okay, but if the party, one of the party that is supposed to deliver fails to deliver, so then for example, the punitive provision in the contract is that he will not be entitled to the consideration if the same is not delivered by the set time at the set place. Okay, so this is a punitive, okay, stipulation entered into the contract. Okay, so the other party fails to deliver at exactly the same time, so maybe delayed by a day or something. Okay, in such case, what happens? What will be the outcome? Okay, application of the law would mean that although the person delivers the goods, okay, but he will not be entitled to any consideration because he is late. Okay, so that's the application. Just an example so that you understand. Okay, so if the matter were to be taken to the common law court, then this party will have no remedy, because yes, that's what the terms and conditions of the contract say. But if that party were to approach the court of equity, okay, court of equity will not merely look at the contractual stipulations, the terms and conditions of the contract. Okay, it will also look at the intent. And what was the intent? What is intent of any contract? It is the fulfillment of the contract, isn't it? Performance of the contract. So here the contract has been performed with a minute delay. Okay, so if no greater harm has happened, okay, then the court of equity will say that, okay, that penalty to a certain extent be excused. That penalty remains, but only to the extent that some actual damage has been suffered due to the delay. And so I hope you guys understood. So that's what is known as relief against penalties and forfeitures. Okay, the said thing has been, said doctrine has been incorporated in Indian Contract Act, section 74, where it says that compensation for breach of contract where penalty is stipulated for. Okay, so when a contract has been broken, if a sum is named in the contract as the amount to be paid in case of such breach, or if the contract contains any such stipulation by way of penalty, the party complaining of the breach is entitled, whether or not actual damage or loss is suffered is proved to have been caused thereby, to receive from the party who has broken the contract reasonable compensation not exceeding the amount so named, or as the case may be, the penalty is stipulated for. So of course it will not be what the compensation has been, what the penalty has been laid down. But then will the maximum amount be given here, okay, as a matter of penalty? No, the court of equity will allow penalty only to the extent that actual damage has been suffered. Okay, so that's the application of this maxim when it comes to contract. The same applies in case of forfeitures. Okay, so for example, a tenant who's late by a couple of days in paying rent. Okay, if penalty is that, okay, if you delay by 3 days, then your tenancy will be forfeited. Yes, under the law there will be a strict application, but under equity it will be different. That some kind of some kind of room will be provided. Okay, but it's not universal case. For example, in the United States, some states are very strict about laws relating to tenancy. Okay, so they do not entitle all such equitable principles. But in England, this is how the maxim applies. Of course, the same is subject to subsequent changes. So under Transfer of Property Act, section 114, talk about, relief as against, forfeiture, okay, for non-payment of rent, as I just told you, where a lease of immovable property has determined by forfeiture for non-payment of rent, or the lessor sues to eject the lessee if at the hearing of the suit the lessee pays or tenders to the lessor the rent in arrear together with the interest thereon and his full costs of the suit, or gives such security as the court thinks sufficient for making such payment within 15 days, the court may, in lieu of making a decree for ejectment, pass an order relieving the lessee against the forfeiture, and thereupon the lessee shall hold the property leased as if the forfeiture had not occurred. So this I think is now clear in the light of the example that I had given you. So yes, how is the maxim applied here? Because forfeiture also, although is mentioned in, for example, in the rent agreement, okay, but that's only so as to ensure that the rents are paid, okay, but the rent is paid, so forfeiture is not that important, because forfeiture is not the end of this agreement. The essential end of the agreement is that the rent is timely paid. If that is done, then forfeiture is not the remedy to be provided to the lessor. So anyway, so that's another application of this maxim. The next application of this maxim is to something called precatory trusts. Okay, now this is you're going to study when sir teaches you trusts. Okay, now trusts could be of two kinds. Okay, one is expressed, the other one is implied. Okay, expressed, implied distinction I need not tell you. Okay, expressed is where the the instrument by virtue of which it is created clearly expresses. Others could be situations in which we assume that there is a trust relation. However, there is another situation where trust is possible. Okay, but this again varies from system to system. In England, it exists. In India, not much. Okay, so what is precatory trust then? So precatory trust is basically the ones in which, it is created with words like I hope, I desire, I hope and doubt not, I recommend. Okay, so it doesn't fulfill all the formal requirements of creating trust, but definitely the meaning which is conveyed here is that you are entrusting someone to do something. Okay, so in such case, it is assumed that yes, a trust has been created. Now, why is it precatory trust? Because it doesn't fulfill the requirements of completely fulfill the requirement of expressed formal trust, but it is nonetheless an expressed trust because it is expressed here. Merely doesn't fulfill the formal requirements. That's why the application of the maxim that equity looks to the intent here. The intent is clear from the kind of words used. And of course, the form is not that important. Okay. The same applies to the doctrine of equity of redemption. I think by now it is quite clear what happens if you remember, in English mortgage is that I transfer a property in favor of B, okay, and because I borrowed certain amount of money from that person. So if the stipulation is that if I fail to pay the money, for example, by certain day, then the property becomes absolute for that person. Okay, now I fail to pay the money, okay, by the deadline, but now I have the money, and if I pay the money, what happens then? Okay, do I have equity of redemption? Under the law, I will not, but under equity, yes, because that transfer that was made was only to secure payment of the debt. Debt is being paid, so the purpose for that is served. Okay, now the property is to be transferred back. So Lord Nottingham had said, in natural justice and in equity, the principal right of the mortgagee is to the money and his right to the land. Okay, so whatever property was transferred is only security for the money. So if the mortgagee's right to the money is realized, even though the deadline has crossed, the right of the mortgagors to the land is protected under equity. So that's the equity of redemption, and that's the application of the maxim. Okay, and I told you guys about statute of frauds. Okay, but there is an exception that equity will not permit frauds to be made and in the engine of fraud or to commit fraud. The same thing is also applicable in India under Transfer of Property Act, Section 53A. Okay, so it talks about part performance. Okay, so doctrine of part performance again is nothing but the application of the same maxim. So, do you guys have any confusion so far? I don't think I need to explain part performance because you guys already studied and enough example have already been taken. Essentially, the idea here is that, for example, certain requirements are laid down for transfer of property, that it has to be written down, it has to be signed, it has to be attested, or it has to be registered. And what happens for some reason it is not, those requirements are not fulfilled, then what happens? Okay, so then you do not have remedy under the law, but you have remedy under the court or under equity. So in India, the same provisions have been incorporated in the statutory law itself. Okay, so part performance is nothing but the same that you see in Transfer of Property Act. So it says, where any person contracts to transfer for consideration any immovable property by writing, okay, signed by him on his behalf, from which the terms necessary to constitute the transfer can be ascertained with reasonable certainty, and the transferee has, in performance of the contract, taken possession of the property or any part thereof, or the transferee being already in possession, continues in possession in part performance of the contract, and has done some act in furtherance of the contract, and the transferee has performed or is willing to perform his part of the contract, then notwithstanding, this is the part, then notwithstanding that, where there is an instrument of transfer, that the transfer has not been completed in the manner prescribed therefore by the law for the time being in force, the transferor or any person claiming under him shall be debarred from enforcing against the transferee and persons claiming under him any right in respect of the property of which the transferee has taken or continued possession. So this right of the transferee, which is protected here despite non-fulfillment of the formal requirements of a transfer, is protected. Okay, and that protection has emerged under the equity, and now in India it has been put in the form of statute. Anyway, there are certain other changes that happened that we will study when we will study Indian Registration Act. Okay, so we'll deal with that later on. But for now, this is nothing but an application of the doctrine of equity looks to the intent rather than to the form. Okay, so is this clear? Is this maxim understandable? If yes, then I will